All right, thank you very much. I actually forgot to ask the folks on the phone if they would like to weigh in on the presentation. So I would like to do that at this time. Are there any comments from the phone?
This is Dave Barr. I was just very impressed. Lots of food for thought. I don't really have anything to add to what was said by the folks in the room. Just very appreciative to be exposed to the professor's presentation and her paper. Looking forward to reading it.
Ann, are you there?
Yeah, I don't have anything to add as well. It was a very impressive presentation and a lot of food for thought.
Wonderful, thank you. I will make a conscious effort to remember the folks on the phone, and if I forget, Krista is going to jump in and remind me. I believe there's a technical issue where we actually have to mute the phones while the microphones are active, and so there's kind of this imbalance of conversation, but I will try to remember to periodically check in. Okay. So welcome back. Next, we will hear from the Oversight and Accountability Subcommittee. As you may recall, at our January meeting, the Oversight and Accountability Committee requested public comments concerning the role of the FOIA public liaisons in the FOIA process. To date, we have received one comment concerning the role of the FOIA public liaisons, which we posted to the public comments portion of the FOIA Advisory Committee section of the OGIS website. Please visit www.ogis.archives.gov for information on how to submit comments, and that one comment is in your folder as well if you'd like to refer to it. So we will now hear from the Oversight and Accountability Subcommittee Co-Chair, Marty. You're up.
Thank you, James.
Thank you.
I just want to touch upon some of the things that we've been able to accomplish, or what we plan to accomplish, and then what we actually did over the last 2 years, and then turn it over to Nate Jones and Mark Zaid if they have things to add. I just want to go back to read kind of what we had focused on some 2 years ago, or close to 2 years ago. We're going to look at current authorities for oversight and past actions. This is program reviews, audits, reports, inspections, and so forth that were completed by open government groups over the last 10 years to determine opportunities for additional oversight. We were going to assess the FOIA public liaison role and determining if there were opportunities to improve there as well. And then we were going to look at past litigation review efforts and additional matters for oversight. So as you know, we've talked quite a bit in the past about the FOIA public liaison role. And what we did is we created a survey. We went out to all 100 agencies that are responsible for FOIA in the federal government, and we received feedback from 90 people in those agencies. The raw data is already on the OGIS website. We created and drafted a report that was shared earlier in the year with this group, and that's also on the website. Some of the things that we had talked about and surveyed the public liaisons throughout all these agencies, and also wrote about and shared the data about, was about the specific positions, so grade, series, things like that, their training, resources, who do they interact with, how often, on what subjects, mainly with the requester community, and then, of course, any comments and suggestions. And it's great to hear that there was at least one comment from the public, because we did go out after our effort with the agencies, and we wanted some balanced feedback. So we did go out for some comment, and at the last meeting, I believe we talked about that. So it's great to get feedback from at least one person, and we would encourage for the public to continue offering that feedback so we can have a balanced approach. And then going into the program reviews, Nate Jones and his colleague Lauren over at the National Security Archive has done a fantastic job identifying over 80 reports and Inspector General reports and audits and so forth throughout the government, and actually it went beyond the last 10 years. I think there were some that go back probably over 20 years from what I recall. And over the last couple of months, Nate and his colleagues had reviewed these, and also this has been shared with the subcommittee. But we did draft, and we're sharing with the committee the report that was put together. And within that, we looked at those 80 or so reports, and basically what could we pull out of there. There were definitely some common themes. There were definitely some challenges throughout the government that agencies face, and some constructive feedback on maybe things that need to be improved and move forward in the government. So that's really what I have to share and touch upon. I'm going to ask if Mark has anything he wants to talk about, and then Nate can provide a little bit more detail on the report that we're sharing with the group today. Thank you.
I'll just add a couple of points. One of the things that Marty had indicated we were initially looking at was dealing with litigation issues. And I think after we were looking at it, and the lawyers on the subcommittee were obviously the ones that were sort of focusing on it, it became apparent in the first initial meetings that was going to be a little bit more daunting and probably beyond the scope of how this committee functions to figure out the litigation aspects and whether significant reform can be done. And Ann, who's on the phone, can weigh in if she wants to add anything on that particular point. What I want to thank the members of my subcommittee, and especially Marty and Nate, who have done a yeoman's work. I think that's the saying, right? An amazing amount of work. And I think what we've done, at least in the tenure of the full committee and through the subcommittee, can now be used by the next committee to look into ways to implement it more. And the work in particular that Nate did and his colleague in compiling this information, I mean, that, if you want to look at what the heart of FOIA is all about, of getting this information and making it available to everybody, and through the OGIS website, having all of these reports now out there, which you never would have been able to find. It would have been absurdly difficult. I remember having a case 15 years ago as the internet was just starting to get the FOIA, we're talking about the FOIA annual reports, and I finally had a client who had the resources where I could put time to get every agency's FOIA annual report and analyze it, because nobody else had that information. Now, obviously, anybody could have the information because it's online, but the difference that time has created. But even with that, what Nate and the NSA, the other NSA, has pulled together is phenomenal, and I think will go a long way in really helping reform FOIA. So I want to thank you guys both in particular.
Thanks for the kind words. So I guess I'd like to start with 3 anecdotes that were released via FOIA. This news agency didn't get this through FOIA, did they? If so, maybe it's time to hire some new redactors. They got a bit too much of an inside view about the same subject while it was going on. This controversial subject, the email says, the risk is that this gets FOIA'd later. FOIA will take 6 months. I say yes, we should just go through the process for the next week, and 6 months from now, when the FOIA comes out, this will all be over. So banking on internal delays. In another case, talking about a FOIA request on the risk of concussions, rather than promptly replying to the request, an email said that they were trying to get another agency to report, quote, with a more favorable review on the issue. Then the person that had written the document leaked the document, and the agency then promptly replied. So these are some anecdotes about the Freedom of Information Act not working. And I think everyone around the table, either as a requester or as a processor, saying, hey, program office, give me the document to redact, and waiting years, on the inside and the outside, have lots of anecdotes but about FOIA not working. But what the FOIA subcommittee on accountability and oversight has done is attempt to compile the data. And like you guys said, we now have every report we can find, and if we missed any, send them our way, and we'll put them up on the OGIS website, on the National Security Archives website. And these reports, again, are from disparate IG reports, Government Office of Accountability reports, many good reports from OGIS, non-government institutions also. So finally, the last thing I'll say is we have the reports up there, and what we did is we went through and culled some reoccurring themes of the challenges that need more oversight. And I'll just give you some bullet points. You can read the full report and give the final conclusion, and then we can have a discussion. So there was some good, especially the new set of oversight self-compliance reviews that OGIS has been conducting. Of all the things, to me personally, this was most optimistic. The bad side is that it would, at the current rate, it would take decades, and agencies have to volunteer for OGIS's insight. And as you may not be surprised, often the agencies that volunteer for a scrub are already the agencies that are doing a pretty good job on FOIA. But they show lots of some positive steps that need to be magnified, such as communicating with requesters, instituting technology, identifying large blocks of requests and getting those out proactively rather than waiting for FOIA. There are positives, and they're in the report. There are also negatives, and the bullet points are not posting enough documents online in accordance with the 1996 FOIA amendments. The only way that we're going to get out of our resource dilemma, if we can, is to stop making it so that people cannot get information on the internet. Not making discretionary releases in accordance with the 2009 presidential memorandum. Backlogs and inadequate searches for documents. Not reporting FOIA abuses. Unclear fee waiver requirements. Not using technology to improve the FOIA training process. Not properly reviewing FOIA releases for segregability. That means essentially de facto denying all requests without doing a word-for-word review as is required, and others. But the basic conclusion that we reached, and again, I thank Lauren Harper for helping to draft this, and also all of the members on the subcommittee, government and non-government, also pitched in a great deal. So Mark was a bit too kind saying that it was our creation. Everyone had impact. But the conclusion that we found was that the current oversight approaches are insufficient in not improving the Freedom of Information Act programs throughout the federal government. The first step to improving FOIA oversight and compliance is acknowledging that the current oversight methods are not sufficient. After this acknowledgement, we can begin to endeavor to create a regime that efficiently and comprehensively ensures oversight of the Freedom of Information Act is being correctly administered with a presumption of disclosure as instructed by President Obama and Attorney General Holder, and holds accountable those who fail to do this. So the first step is to say that the current regime is insufficient and we have a problem, and hopefully the next subcommittee, I sincerely hope, will be able to go further than we have in tackling this problem. Thanks.
Okay, I'd like to turn to the phones first, if possible, to see if they have any comments. Ann?
Our AV technician just ran out of the room, so we might not have them yet.
He's back.
Can you hear me?
We can.
I want to thank the subcommittee for the incredibly hard work it's done, and I definitely agree with Marty. I think that this is lays down a good foundation that hopefully the next facts committee will pick up. That's it. No
This
great
is Dave.
insight.
This is Dave Barr, and I echo Ann's comments. This is an excellent foundation. A lot of hard work went into this, and hopefully the next committee can take the baton and move forward with it.
Thank you. Okay, I'll just echo that a little bit if I can start. Just thank you for the hard work. This is something that, if I switch hats and just talk about OGIS briefly, these reports have guided our assessment program, and it is something that we do review not only prior to going into an agency, but the entire program itself to see if we could identify themes and trends as well. And so you guys have done a phenomenal amount of work and created really a public service for us as well. Okay, anybody else on the committee? Yes, sir.
Yeah, so this is Sean Moulton. So I'm just curious, in the reports that you guys reviewed, maybe it wasn't a common theme, I don't even know if it really came up, but I was curious as whether or not there was much discussion about best practices in terms of internal management in the FOIA offices, the use of multi-track and proper use of that to keep the simple requests circulating and getting out quickly, or internal metrics in terms of evaluating how long it's taking, or performance of individual FOIA reviewers, things like that, whether or not that was a topic or not.
It was, but it was so incredibly varied that I would have to go back and read all 80 reports and write another report to say, here's what this agency suggested, here's what that agency suggested, here's what this agency found out works, here's what OGIS may know better than I. But it was an incredible variance. There are FOIA shops with one person and FOIA shops with 10,000 people.
And I think that's what was so striking, is that it did vary. Even some of the best management practices that are just would be standard anywhere else, they don't seem to apply to FOIA. And there's really no good cross-comparison to say that what works at the State Department, which is a large organization, would work at a small organization where there's one or two people. That's something that we're endeavoring to try to understand ourselves. We do have best practices published, but we haven't differentiated ourselves to say that it works really well at DHS, but it would not work at TSA, which is much smaller component of DHS. But I think that's kind of like the first step, is to actually say what are good management practices that can be applied to a FOIA organization.
Because it may be that there are characteristics or particular profiles where we'd have 3 or 4 different types of agencies, and what normally would work best if your agency is small or high volume, or different characteristics where you might fall in.
One of the things that we've done, this is not only it's reminding me of the best practices series, which is also part of the NAP 2.0 commitments. Mm-hmm. The whole idea there is to find practices that are working and are successful, and to have those agencies share those practices with everybody else. And we have had one specifically for small agencies, for example, and it was very remarkable to me that the small agencies were doing very much the same sort of things that the big agencies were doing in terms of using technology and working on proactive disclosures. For a very small office with very small amounts, the small agencies had a lot of really good practices too. But my comments, sort of to echo what you're starting to raise, Sean, was when looking at this report, was that we still have so many other mechanisms. But in addition to, obviously, IG and GAO reports, we've got chief FOIA officer reports, we've got annual reports, we've got assessments that are done by civil society groups, like your assessment, we've got the assessment that OIP does. We have mediation services, which is not factored in. How is that impacted? And then we also have the role of the chief FOIA officer, something that the archivist mentioned earlier. We've had a mention of the chief FOIA officer. That to me is a real, obviously it's a pivotal position within an agency and has tremendous capacity to help improve any agency's FOIA operations. So one of the things that struck me was that we have many additional quote unquote oversight mechanisms that we could add to this discussion and see how all of those collectively are impacting FOIA administration.
And I think Melody brings up a good point, that there are a lot of mechanisms out there. But one of the striking things from the reports to me is that there's also, you can have management practices that work well too, but most of these reports are not done by subject matter experts. And that is also a very important component. And I think that's the piece that OGIS brings a little bit of as well, right? Because we understand the FOIA process. A lot of times the IGs are brought in, they're doing a very particular type of review, right? They may be focused on a certain subject. GAO may be focused on maybe some broader management issues or budgetary issues. But even when we give our comments back to the agencies, what we find is like, well, thank you very much for these comments. Now, can you help us? Because we really don't know what the next steps are. You've given us 5 recommendations. So I think that whatever oversight piece there is, you have to have that next piece that will also enable them to accomplish whatever it is you're asking them to do. Because they just don't have the resources and sometimes the knowledge to implement what you're saying. Karen?
Hi, this is Karen Finnegan-Myers. The one thing to keep in mind, too, with all the reports is that they seem to focus just on the FOIA program. The FOIA program is providing a service, and it's part of a team that makes the FOIA work in any department. So if there's no focus on the other parts of the team in conducting timely searches, providing the documents, providing input on sensitive issues, then whatever oversight or changes you make in the FOIA program will only be partially successful. So maybe that's something for the next subcommittee to keep in mind, that the focus can't just be on the FOIA program's management. It has to be a team effort by the entire department or agency.
Thanks. Just a couple of comments. I guess I'll have 3 just main general points. The first is, I think that what the report showed me, at least collecting them, is that reporting is important, but it cannot be the end-all, be-all of FOIA compliance. And there are all sorts of reports, and the IG reports may at times miss the mark, and that goes to the point that reporting is not necessarily compliance. Which leads me to the second point that I take very well, Karen. In all of the best FOIA agencies, there's strong leadership from the top down support for the program, and the programs are well funded. That's something that came very through from the reports. And the last point is kind of my suggestion, well, what should we do? And in the report I say that there are problems of funding, there are problems of jurisdiction, there are problems, but the solution, I'm more and more convinced, is that we need to move away from oversight as reporting numbers and having good statistics, and we need to have a FOIA watchdog and a FOIA beat cop that gets in the agencies, asks the tough questions, officially or unofficially, knows the process, and when someone has a problem, someone else in the agency won't respond to the request for documents, or the requester thinks that something's over-redacted, there's someone to go to that will say, show me the documents. Again, you have to have an agreement to do this. I know it won't be easy. Here's what we think should have been done. And again, be the watchdog, be the beat cop. I think that's the direction that we need to go to improve FOIA oversight and accountability. Thank you.
Yeah, I mean, my hope is for the next committee that they can take a lot of what we did, which were more sort of pie in the sky, and now they start focusing narrowly on oversight issues and practical aspects. And I think even as we heard from today, where identification of legitimate issues on proactive disclosure, but then hearing from an agency then saying, well, wait a minute, there's some practical things you don't know because you couldn't have known, that things would be different. And I'm not sure how federal advisory committee rules work. I know we had some issues in dealing with it, of seeing how the committee can deal more interactively with the agency representatives, not just the reps on the committee, but the day-to-day people, to figure out some of the more practical aspects to be more efficient, to see what would be more helpful at different times. Like for one example, I can't remember which agency, I'm still getting response letters that say, yeah, we've received your request dated whatever, it's assigned this number. I don't have a clue what request they're talking about that I sent them, because I'm not tracking it by date. I know the subject, I know the client, and that's not helpful. You know, that's a nice little practical point that we haven't gotten down into the weeds with this. And sometimes I miss responding to it because I don't know what request they're talking about, and I sue them, and then they tell me, oh, we never received your administrative response. I'm like, well, what were you talking about in the first place? And so it's on both sides with something like that. But you know, this, I think, is a great framework to then take the next step. And maybe the committee can get access to these other internal reports if the agencies feel. That would be good proactive disclosure, some of these internal agency reports. And then I think finally, and we talked about this in the very beginning of our tenure, and it's probably a little bit awkward for OGIS, since you are running the committee for the most part, of looking what to do to strengthen OGIS, if that's in fact what is needed. But in many instances, our best advocate can be obviously internally, that one agency or one component is talking to another component. Now, sometimes it's internally. If I can call Jim and say, Jim, I'm having a problem with the Army, and Jim will fix it and address it. Or I used to call the State Department all the time when they would mischaracterize my law firm as a commercial requester on behalf of a client who was a journalist. And I'm like, guys, you're missing who the requester is. It's not just my letterhead. And that goes to what Nate's talking about, the leadership and the strength from it, rather than some of the anecdotal examples that you gave that unfortunately we come across and are probably, and I probably would say, are not reflective of the FOIA community within the government. But I think we need to root those out a lot more, and hopefully the next committee can go down further into the weeds to really improve on FOIA, taking into account what we've done as a much broader sort of up-in-the-sky recommendations.
Thank you. Okay, I want to go to the phones real quick and just make sure, do we have any comments from the phones?
No, I agree with a lot of the sentiments that have been expressed. This is Ann Weissman, especially Mark's point. I mean, as I said, I think this is the foundation, but we recognize that there's a lot of work to be done.
This is Dave Bauer, and I think this subcommittee, really was grappling with a very broad scope of issues, and I think what was accomplished in the 2 years is foundational, and my hope is that the next committee can take what's started here and maybe pick a manageable subset of issues and try and drill down and make some real progress on them. I think this, basically, this committee was asked, what's wrong with FOIA? This subcommittee. And they did a great amount of work by identifying some threads that can be followed here. And so my encouragement would be for whatever manifestation of the next committee following us, that they take this and move with it.
Thank you. David?
This is David Pritzker. I just wanted to ask Nate a question about your concept of what you called the beat cop. Do you see this as a redefinition of the public liaison, or do you see it as a different function? Should it be a replacement of the public liaison? What if anything, is the connection?
I don't think it's, I don't know. I'm speaking theoretically here. I think that the FOIA public liaisons, I don't think are situated in a spot to be the beat cop. I see the beat cop as another agency outside of the agencies that knows FOIA A to Z, whose primary function is listening for complaints or problems at agencies, knowing problems, walking around, knowing the FOIA people, and having able to be access to see what's happening at any agency. So I primarily see it as an ombuds office or someone outside of the agency to enforce compliance. So no, probably not someone within the agency looking at it. I think the IGs do that already, somewhat.
Before you use the term, I was thinking, sounds like an ombudsman. So an obvious question to ask is this a function that could be put upon OGIS?
Well, I think the first step is for OGIS to have more legislative authority. I won't get into the weeds too much, but to be truly an ombudsman, an agency has to be independent.
Well, that's kind of what I'm getting at. If it takes legislation to do it, is that something that we ought to be recommending or considering?
I've been shouting it from the rooftops personally. Yep. I'll let OGIS talk more about it if they want.
I make a motion
has full authority to do
Anything it wants in the FOIA world and tell every agency to disclose.
Second. Well, we thank you for that. Exactly. So, do we have any other comments? I do want to I think that it is foundational work that you guys have done, and it really sets us up for the next term. So I look forward to a robust conversation regarding these very important issues that you've raised. I want to invite the members of the audience to come up, and if they have any comments or questions, please just remember to state your name and your organization. Do we have any comments? No? Okay. So at this time, we're going to move to the fee subcommittee report. At our meeting in January, the fee subcommittee co-chairs Jim Hogan and Nate Jones presented on the subcommittee's proposed memo from the committee chair to the archivist. The memo recommends that the director of the Office of Management and Budget review and revise OMB's FOIA fee guidance. The draft memo presented the archivist with 3 options. Option 1, the archivist asks OMB to revise its 1987 guidance. Option 2, the archivist make a legislative proposal to Congress to amend the fee provisions of the FOIA by revising the various fee standards, thereby enabling agencies to standardize fee determinations. And then option 3 was to keep the status quo and not make any changes to the fee provisions. At our January meeting, the committee unanimously voted to consider option 1 as the recommendation going forward, with the fees subcommittee reviewing OMB's fee guidance and updating the draft memo based on the subcommittee's review of the guidance. And as you may recall, Mr. David Pritzker expressed concern that the options as drafted stated that OMB should update its guidance and/or a legislative proposal should address fees. However, neither option described what to do or what changes are needed to the guidance. Mr. Sean Moulton concurred, and I said that the fees subcommittee could draft something more specific to circulate among the committee with the goal of having a product for the committee to vote on at its April 2016 meeting. And since our meeting in January, the fees subcommittee updated its draft memorandum and drafted recommendations concerning OMB's fee guidance. And I will now ask the fees subcommittee co-chairs to report on their activities since our January meeting. Gentleman who wants to begin?
Yeah, this is Jim Hogan from the Department of Defense. We don't have a copy of the memo. I don't think it was handed, but you do have a copy of the proposed recommendations. Oh, there it is. Okay. Sorry, I missed it. But anyway, what we did with the memo, and it was circulated, was basically took out the 2 options. We originally had given the archivist a choice and said, okay, as James pointed out, it was the view of the committee. We should say, here's what we want, where we want to go forward. And so that is the memo basically just changed to take the 1 option, and where we're asking the archivist to have a memo sent to the director of OMB saying, basically, it's been almost 40 years now since the fee guidelines were, and a lot has changed in this 40 years. Given that there's even a further change in the FOIA Improvement Act, and whatever version, if any version is passed, there might be even more change necessary from OMB. But anyway, we had circulated that, and then we also circulated our proposed recommendations. And we have a list of 6 recommendations that the subcommittee thought these are things that we can recommend to OMB to look at. Now, again, these are recommendations, understanding the bureaucratic process to get things through at any time. And if the archivist does prepare a memo, his staff will look at it, and attorneys, and these things may be changed. We understand that. And OMB may look at a few of them, and also, so, I don't think we should have the view that this is definitely what OMB is going to look at. There's a lot of ifs in there, but this is basically what we looked at as the thoughts of the subcommittee going forward. And what we looked at, and some things to be, and we discussed and debated them. So I'm not going to go read them all through. I think if everybody's read them, unless Dr. Holzer. Oh, okay.
An opportunity as well if they want to comment.
Okay. The FOIA Advisory Committee recommends that the updated Office of Management and Budget fee guidance should, item 1, Provide clarity by clearly differentiating between two separate yet related issues, fee waivers and requester fee category status. Agencies need unambiguous, uniform guidelines on the criteria that must be met for each fee category. These guidelines should reflect the President's and Attorney General's guidance on FOIA and relevant case law, including embracing members of the media who publish primarily through electronic means. 2, provide agencies with additional guidance on what constitutes a representative news media that takes into account the changes in the journalism profession over the past 30 years due to technological advancements. These guidelines should be fair, balanced, and better enable agencies to make accurate fee category determinations. They should also clarify that fee categories are determined by the identity requester, not the particular request. 3, incorporate statutory changes to the FOIA relating to when FOIA fees can be charged. This includes Section 552(4)(a)(8), which states that certain fees cannot be charged when an agency fails to comply with any time limit if no unusual or exceptional circumstances apply to the request. Clarification is also needed as to which fees may be charged if the 20 working day statutory time limit is not met because unusual or exceptional circumstances exist. And just as an aside here, as mentioned before, there's consequence for commercial requesters in this too. Because we would not be charging, or agencies would not be charging fees, search fees to commercial requesters if the time limit is not met. 4, provide guidance on fees associated with reproduction costs, including providing electronic copies via email, CD, or DVD. The guidance should also clarify the costs that may be charged for reproducing documents that are transferred from classified to unclassified systems so that they may be released electronically. And just a little explanation of that. Some agencies have to process on classified systems. They're not connected to unclassified systems for obvious reasons. Right now, the most secure way is once you've done your redacting, print them out and rescanning. As you can tell, that's resource, time and money intensive, could be. There are systems that, and I'm not all that familiar with them, I know some people in the telecom community are more familiar with them, where you can take it and there's a process, there's a software, I don't know what it is, but to basically take something off, to say your top secret system, and put it on your secret system, but it's an intensive process, it's a resource-intensive process also, so that's just a consideration here. That's so it can be provided to request electronically, posted, et cetera. 5, explain that agencies may use their administrative discretion rather than a formal fee waiver to decide not to charge FOIA fees when the interests of the United States government would be served. And 6, recognize that FOIA fees cover a very small percentage of FOIA costs. In fiscal year 2014, agency processed 647,172 FOIA requests at a cost of $462 million and recouped just $4.2 million from FOIA fees, less than 1% of the reported cost. Moreover, these fees are paid to the general fund of the Treasury, not to the agency's FOIA offices. The current OMB guidelines appear to be missing a word in Section 8, which adds ambiguity to this expectation. Just put that in because we kept reading it. We could not find any source that's missing that word from Section 8. So that's what we propose, and I'd like to open up the discussion on those six recommendations.
Okay.
Yes, Larry.
Sure. Let me start number 1 is, I think the recommendations are great, and I really appreciate all the hard work. I'm a little concerned about following the policies of the Attorney General or the President, in light of the fact the last time we issued fee guidance was 40 years ago. We've had a few presidents and attorney generals. Mm-hmm. So if you build fee guidance based on the current administration and the next administration, whoever that may be, they're going to lose their value 10 years or 20 years or 30 years down the road. So it may be just a more prudent way to make it based on case law, statutory guidelines, and other things versus the desires of the President and Attorney General, whoever he or she may be. Just on the second, I'm just going to go through I've got a couple issues. On the second one of the challenges a lot of us are having, at least we're having, is you're having more and more, in essence, commercial organizations, law firms and other commercial groups, creating either media outlets through their organization. So it's like they'll create a 50c3. We have a law firm that does that and has a 50c3. So when he sues the agency over an X, all of a sudden his media component makes FOIA requests for the exact documents he'd get in discovery or try to get in discovery. So it'd be nice to have some kind of guidance to that kind of type of situation, to say if you're media, because you publish a newsletter that you sell for, to 20 people for $100,000 a piece, is it really media? It's a real gray area that sort of bothers me. And the last one I've got.
Excuse me, that would be, one thing about it, it's like a commercial newsletter.
Commercial newsletter, it's I'll give you a law firm, and I'm not necessarily a law firm that's a public interest law firm, but a law firm is out there representing commercial entities. Let's just pick on General Motors or Tesla this day. So they represent Tesla, and Tesla's in litigation with the agent, they represent Volkswagen. And therefore, they're suing EPA, and they're defending EPA's allegations about pollution of diesel cars. So they'll then create a 50c3 organization as part of that law firm to make their FOIA requests or try to avoid fees. And they're saying, we also are media because we publish a newsletter.
Right.
It's just a difficult area in a lot of ways, because legitimate 50c3s, legitimate media are being put at a disadvantage, I think, as a result of these.
Yeah, I've seen that from another commercial entity. Okay.
And the last one in number 5 is, whenever you have discretion in waiving something, to me, it's problematic. My argument is you treat everybody fairly or unfairly, but you treat everybody alike. So if we're creating some type of, in the best interest of the United States, there needs to be some real concrete place to ground it. I don't know what that is. It's because the government's being attacked, so they say it was a result of being attacked, we want to release records. The government has a right to release any records it wants proactively. My concern is if you're treating people differently under FOIA. And FOIA, you treat everybody fairly. You don't have to ask why they're asking for their request. Accordingly, in my world, we probably shouldn't. I don't think we should be just saying, well, because it's in the best interest of the government, we're going to waive fees in this case, but in this case, we're not. If the agency wants to release records proactively, they can outside the FOIA arena. And that's just a real concern of mine, that we'd have this ambiguous standard that we're treating people differently based upon what we think is right. So, sorry about a few comments, but
No, it's good.
I think it's a great piece. I just think those are where some clarity needs to be raised.
This is Melanie. My one concern, I was fine with all of them. My main concern was with number 5 as well, because I worry about just having unbridled discretion, that the concern with a lot of the other things that I think everybody collectively is mindful of, that we want the guidelines to be more up to date and to take into account the new ways that members of the media disseminate information, all those sort of the technology-driven changes that have happened over the intervening years. But part of the concern is the lack of guidance, the lack of consistency. And so then it seems to me like we're undercutting the message that we want greater clarity if we then say, oh, but we want like a totally open-ended, not bounded, or bounded in only the very smallest way, a provision. I would be very nervous that somebody would say, well, when I go over to this agency, they always give me a fee waiver, but this other agency never gives me a fee waiver. I feel like we're just setting ourselves up to have requesters be very frustrated that they're treated differently and not even knowing why.
Yeah, my thought, and I definitely understand what you're saying.
Yeah.
The earlier things, we're trying to eliminate ambiguities and issues that are subject to judicial review. Whereas I don't know would that administrative discretion become subject to judicial review? I don't know. Could it?
You get it, would sue saying you're treating me unfairly because you're treating me differently.
You're treating me differently.
But it also seems to be setting up that discretion outside of the normal fee waiver process,
Right.
which seems somewhat
Right.
problematic, that you're just giving discretion to an agency to wholesale waive fees without it maybe even being asked or denied.
Whereas the statute gives a standard. So
Right, I agree.
the benefits of a standard is everyone understands, here's the standard, here's what I have to show in order to get a fee waiver. The agency in turn knows what it has to determine to give a fee waiver. So everyone has, both sides of the equation know what the standards are.
And I will tell you, the idea of actually giving that discretion in my experience and from our oversight function that, OGIS does, agencies appear to already believe that they have this, just because they're not charging fees for whatever reason. And that is problematic, because then when a FOIA office is able to charge fees, they reduce the backlog, and now they're like, okay, now we're gonna start charging fees. Everybody for the past 10 years comes back when they're, they submit a FOIA request, and they say, well, why are you charging me fees today? You didn't last week.
Well, this is Dave Bauer.
Yes?
My response to those are valid comments. I understand that, but for instance, FOIA already affords the agency's discretion as far as the withholding exemption, and that doesn't seem to be extremely problematic. It's the president and the attorney general's memo both emphasize that agencies should be mindful of the fact that they have the authority to release information under the discretionary release authority, which goes right to the heart of the FOIA. And that does not seem to be problematic. Also, I will point out, until very recently, my understanding is that this policy was OGIS best practices guideline. That it was, I believe it was until last fall, OGIS on its website said, hey, agencies, don't forget you have the authority to waive fees under your administrative discretion. And there was no floodgates opening up as far as litigation that I'm aware of that found this to be extremely problematic. Agencies have discretion. The concern about litigation would be if the agencies abuse that discretion. At a certain level, we have an expectation of good faith and best practices on agency personnel when they apply their discretion. And, my personal preference would be just to get rid of fees, because they're a source of contention. They don't go back to the agency, and whatever amount of fees are recouped are an infinitesimally small fraction of the cost incurred. And it would just seem like all of this would go away if fees went away. But I understand that I'm probably going to lose that argument, at least with this audience. But I see this as a relatively innocuous provision that can help the agencies deal with this process, particularly when the costs are low and the hassle of arguing over fees is high. So that's my opinion.
All right, thank you. So this is James, and I just want to address the point about OGIS best practices. So there was this 2012 best practices for FOIA regulations that I think everyone's pointing to. So I want to point out that those best practices for the FOIA regulations document were removed in 2014, prior to my arrival. That doesn't mean that I don't disagree with the removal. And that removal did include the language regarding exercising administrative discretion to waive fees. But I think that there are some important distinctions between what OGIS presented as a best practice for FOIA regulations in 2012 and the recommendation that's currently before the committee. For one thing, the 2012 best practices speak to agencies using discretion within the statutory framework. And I think that's very important. The subcommittee's recommendation, on the other hand, specifically states that the agency should have discretion to waive fees outside of this framework. So while OGIS's recommendations was made within the regulatory context, which allows agencies to consider whether the proposal would work for the agency and either accept or reject the recommendation, a recommendation to OMB to update its fee guidelines, which are binding to all agencies, is a very different matter. So that's the point to the best practices, which, by the way, we did have this conversation previously, and I was unaware of the 2012 best practices that were issued, and I was also not aware that we removed them in 2014. But I do think that it's important to just have that out there. Yes, sir.
Jim, this is Dan Weisman. I'd like to address some of the concerns that have been raised. I want to note at the outset that in putting together this recommendation, the subcommittee did reach out to OIP on this very issue to get its views. So they were given so some of the concerns we're hearing voiced today are new to the committee, to the subcommittee. but more substantively, in my experience, on both sides of the FOIA, I have has been that there is a lot of confusion and concern about whether an agency has the ability to waive fees in a circumstance where, if they have to litigate the issue, the cost is so much higher than anything that they would recover. And there has also been confusion, in my experience in the past, about the legal authority of an agency to waive fees. I think there was a view held by Melanie Paste's predecessor that not charging the fees would be a violation of the Anti-Deficiency Act. That's not a view I support, but just to say that we're not writing on a blank slate. And so, at least from my perspective as a member of the subcommittee, I thought it was important to have something in there that makes it clear there is no, as far as I'm concerned, statutory prohibition on an agency waiving fees. And I very much agree with Dave Baer that a waiver of fees, whether or not it involves an exercise of discretion, is entirely consistent with the underlying purposes of the Act. And there are plenty of other parts of the statute that require an agency to apply a certain amount of discretion. And that's never been offered as a reason to get rid of those provisions altogether. And I think this is the same. If we have experience from it that shows that there is this unbridled discretion is being abused, we can revisit it. Or maybe it's a role for OGIS, for example, to write some guidelines on factors that an agency should consider in exercising its discretion.
Thank you, Anne.
But I think it's an important point, and it's an area that has been one of great confusion. And I think the goal of the fee subcommittee was to identify areas of confusion where having guidance from OMB would be especially helpful. Thanks.
Thank you, Anne. And I don't think anyone in this room is not appreciative of the work that was done. I mean, we can all see it in the recommendations, and based on the conversation that we had in January, there's been a tremendous amount of work to get us to this point. The one thing that I would point out is it does seem that some agencies have used this kind of discretion already, and it has increased the tension between the requester community and the agency. Our own report, the subcommittee's report, identifies an agency that allegedly used their discretion to make releases to requesters that were favorable to the government's position. I mean, that's an allegation that was investigated. And so when is it in the interest of the government to release a record? I think we may not end up where we want to be on this issue, to be honest. Yes, sir.
I guess I'd just like to, first of all, echo what Dave said earlier, that I don't think that this point, if it's so contentious, is the reason to blow everything up. But I would like to speak on behalf of using administrative discretion, and I hope that whatever happens, that this isn't a sign that the subcommittee agencies just stop doing it, because from my perspective, the best agencies already are doing it and probably will continue doing it. I'll also note that there are, at least in our search, 4 agencies, some of which are on the table in their FOIA regulations, do say use this administrative discretion. So the reason for it is that the status quo is already that it's contentious and confusing with formal fee waivers. OGIS did a blog post essentially saying it's a much higher threshold for consideration for a formal fee waiver than a fee category. So essentially telling requesters, if you can, please, 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 just try and say you're news media, because this formal fee waiver is very subjective. In fact, in the latest stats that I found, it's granted for only 1% of all FOIA requests. So it's not like I would just say that the current situation is also confusing. That said, I take the concerns and hope that we can move forward.
This is Dave Barr, and I wanted to point out that one of the 4 agencies that were identified as employing discretionary administrative fee waiver of fees as opposed to fee waiver is the National Archives, I believe, the entity which has chartered the committee that is meeting today. So you know, I find it ironic that if the National Archives finds that workable, that we're stumbling over this provision at this time.
Melanie?
This is Melanie Mistay. So, first of all, I definitely am, and I feel very confident. I certainly am not do not in any way want to blow up this recommendation. I really think it's a great recommendation. So I want to be very clear that I support the idea of going to OMB and asking them to update their update the fee guidelines. So my only concern is really with this particular piece of the recommendation. I also want to say OIP was not consulted. Again, for the record, we were not consulted on this. I would have told you, anybody who asked me then, the same things I'm telling people now. The third thing is that the fee waiver standard is in the statute, so that gives us the basis to operate. And lastly, the difference between using discretion with exemptions, because this is something I thought about, is that you're not treating requesters differently. So when an agency decides as a matter of discretion to release a draft report, it's now releasable to everyone, to all requesters. But if you have unbridled discretion for a fee waiver, that goes requester by requester. So you're treating it, and that's my big concern, is that we would be asking agencies, putting agencies in a position of treating requesters differently. And I just feel like could be very problematic.
Okay.
Or even treating the same requester differently on different requests.
Yeah, no, that's
I
true.
mean, you know, so I mean, clearly, if it's something that somebody thinks is strong, at least get OMB to put some guidance together on when you can actually discretionally waive the fees. Just saying to an agency when it's in the government's best interest to waive the fees, it's just such an amorphous standard that's really difficult for an agency to apply and for the courts to address.
So,
We talk about fairness. There's a lot of unfairness, to some people would think, built into the FOIA. If you're just a requester asking for information that have no organizational connections, it doesn't seem fair to you that someone, because they work for a news media outlet, can jump in the queue ahead of you. It doesn't seem fair to them out there. Or that they may have to pay and people don't. So there's sort of, in some ways, unfairness built, but there's reason for that. Whatever some people say unfair, other people say is fair. Talk about taxation. Okay, that's one thing. Okay, you get 5 different ways to tax people. It's all going to be unfair to someone. In the Department of Defense, the only time I'm aware of this happening, and just say, to me, it was fair, it would be next of kin. If a soldier dies in battle, there's an investigation. And normally the primary next of kin will get a copy of that outside the FOIA. It's a FOIA-like release. We give it to them without having to go through the FOIA process. We have instructions that say how to do that. And so they get it. But they could actually ask for other information, other documents outside of FOIA. I know components of DOD just say, we're not even going to charge the next of kin fees. I mean, to me, that's good. We don't want to. Usually the fees aren't involved anyway because the search is easy and you give them electronically, you're not going to involve fees. But I do know some people have done that, and they said, we just don't feel right doing it. I understand that. That, in a way, if we could have it bright, and you say unbridled, I agree with you, we don't want unbridled, but then we'll be getting too much into agencies determining categories, fees, et cetera, type of people, et cetera. Would agencies become unbridled? That's conceivable, because as with everything, it's those unintended consequences. And we look at the FOIA Improvement Act. What are unintended consequences from that potentially? And both sides of the issue, we're looking at, say, okay, what could happen? And those things aren't predictable. If the unintended consequences that we may conceive being, from Exemption 5, or excuse me, from Recommendation 5, be something we don't think we want to happen, then that's fine. That's fine. We can't predict the future, but we have to look at what the risk is.
So the only thing I just kind of want to address is this kind of process question. So
Sure.
This is normal and encouraged for the subcommittee to bring their product forward to the committee. I mean, this is how it has to happen. And then that there would be a vigorous discussion, which is something that I really wanted. And so I'm excited to have this today, okay? And, there's been talk of blowing up the recommendation. It's the will of the committee. I mean, this is the way these things work, okay? So because of the time constraints, I think we've all basically have said our piece on where we stand on it. What I'd like to do is right now to invite comments and questions from the folks in attendance, because I think that this is an important issue. So if you have a comment, please approach the microphone, and if you have any questions, please just state your name for the record, please.
Sure. Hi, I'm Cindy Cafaro. I'm from the Department of the Interior, and at the risk of outing my agency a bit, in our FOIA regulations, which I implemented, we do have certain circumstances where we will grant a fee waiver, particular instances, for example, if it is someone asking for a single copy of records concerning themselves, and we have a list. And I think that that is a situation where I can look at my people and say, here it is, and if a requester is ever wondering, wait a minute, why am I not getting a discretionary fee waiver? You can say, oh, well, these are the situations, and here it is, and this is why this person qualified and this person didn't. But I have to say, I'd be really, really concerned about a situation where it just said the government's best interests. I have, hundreds of people working on FOIA all over the country, and what one person's idea of best interests is not the same as another's. And we have some requesters that are particularly aggressive, frankly, and that would be, sort of screaming on doors, and all they have to do is meet one person who's, more amenable or just is tired of getting yelled at and says, fine, it's in the best interest of the government. And then they'll be going down the door. Well, this person in your very own bureau. I mean, as we were, sort of hearing people say, well, OJIS said this, and, in 2012, OJIS said this, we'll be getting that same kind of thing. And so I think that it makes a lot of sense. Obviously, we're doing it ourselves to have a situation where there can be these discretionary where there are these areas that will go a little further than the statute itself, but I think they need to be very clearly delineated, and any guidance that OMB could offer about that clear delineation, I think would be very helpful. So maybe asking them to provide us more guidance rather than to provide us something that open-ended might be the way to keep that in.
Thank you.
Michael Ravnitsky, private individual. I think the big picture is the importance of the committee moving forward some recommendation to OMB to look at this issue because of the age of the existing document. And I would hope, as a member of the public, that a small disagreement over the exact wording and nature of one element of that would not hold up the process, given the fact that this is the last meeting with this particular group, and reformulation of the group would tend to slow down that process. So I would like to suggest that there be consideration of a more generic reference to that particular concept in that element. In other words, suggest to OMB that they examine the question of discretionary fees, or suggest that agencies should be given, should be informed of their opportunity to build in discretionary fees into the system, because most agencies use that routinely, and they do it based on things like undue delay or problems encountered, or the nature of the request, as Jim was saying, next of kin. There's specific things in each agency where that may arise, where the circumstances are such it would be the kind of thing they wouldn't want to do, is to charge fees in that particular request. And it's not unbridled. I think it's important, but maybe leave it to the agencies to determine exactly what their criteria are, but encourage them to establish some sort of mention or criteria in their regulations. But in that way, maybe OMB, this could be brought forward and not be hindered in that respect. Thank you.
Thank you very much. Okay, so now that we've heard from our subcommittees, I'm going to...
Can I just, if I may, just real quick, 2 points that Larry brought up, but we really did not discuss, and I just want to give my comments on that and see where we think. On recommendation 1, and I don't know where this falls in properly, take out the President's Attorney General's guidance on FOIA and reword that. Now, whether we should discuss the exact rewording now, since this is the last meeting, or if we'll get back to you on that. And then the second point, I think that gets a little bit too specific and there's a lot of issues like that, and if we get too specific in here, I understand because I've seen it. Yeah.
It's one of those issues,
So that's all I have. Go ahead. Sorry, Dr. Holden.
Yep, thank you, sir. Okay, so now we've heard all sides of the discussion. I will request a motion, and I'm going to go into some of the general guidelines of how this is going to work. I know this is pretty much our second real big vote, so there was some confusion last time. So I'm going to go through the rules before I actually entertain the motion. Okay. As a reminder, any committee member may move that a committee take a vote. Motions do not need to be seconded, although I encourage them. Okay. I request that members raise their hands to obtain the floor. Before we take any voting, as chair, I will restate the motion before voting. We will do a voice vote. If you're in favor of a recommendation, say aye. If you're against a recommendation, say nay. And if you do not wish to vote, say abstain. Krista, our DFO, will record the votes, and we will announce the results of the vote. Okay, so as you are aware, at our January meeting, as a committee, we unanimously agreed to make a main recommendation that the archivist ask OMB to review its 1987 guidance. The fee subcommittee has submitted an additional 6 sub-recommendations suggested for inclusion in the main recommendation. I would like to read each of the 6 sub-recommendations and seek your vote before the committee votes on the main recommendation. Okay? So you're going to, just to be clear, you're going to have an opportunity to vote on all 6 sub-recommendations, and then we'll vote on the main recommendations individually.
And point of clarification, if we're going to go, can we offer amendments to these 6? Because if we're going to vote on the way they're written, I would have more concern than if we were able to quote-unquote edit as we go along.
I would leave it to the will of the committee whether or not they'll entertain amendments to the vote. I would, without presupposing an outcome, think that I first would like to entertain the subcommittee's recommendations as written, and then if there's clarifications or points of amendments, then you could do so at that time, and we'll vote on them. I will tell you I'm not an expert at Robert's rules, but we will do our best to make sure that this flows through and makes sense and that we're following the procedures. Okay, so once I finish reading each recommendation, I will seek a motion from the committee members. I will then call out your names one by one to get your vote so that Krista can record them. Are there any additional questions?
Yeah, so are you saying there will be an appropriate point to introduce an amendment to each of these?
I think I will ask for a motion, and if there is a motion and the vote either carries or doesn't, I guess you can intercede prior to the motion being made. We could have dueling motions apparently as well.
Robert's rules, you can have a motion, then you usually have discussion on the motion, and that's when you can make amendments to that, and then you can vote on the amendments, then you vote on the underlying. I used to do this stuff, so.
That is not in my script, but that's fine. We can do that.
And whatever works for everybody, it's just,
That's a very appropriate way to handle it.
It is. I think it is, but I do want to, I think that, that's an appropriate way of handling it.
So it sounds to me, based on the discussion we had, that there's probably only 2 that we're even, maybe 3 at the outside, that we're even considering changing the wording on, one of which it might not be about wording. But, so I'd rather see if there were any real quick, if there's rewording, and then go through and vote. I don't know if that has any weight, but.
Or I can make a motion with deleted of 4 words, and would that work?
Very possibly.
Why don't we get,
Sure, whatever you want.
Let's go through it. The idea, obviously, I'm sorry, guys, but we are on a timeline. The meeting is going to end. The archivist does have other places to be. We can always, and this was an option at the very beginning, we can table these recommendations and have the next committee pick them up.
No, I think we don't like that.
I will also point out, just so nobody thinks that I'm being heavy-handed, these were submitted by the subcommittee well over a month ago. The entire committee had an opportunity to comment and to present any comments to the subcommittee. So obviously, at any point, you can make a motion. There was plenty of an opportunity for that to occur prior to today. So I'm not trying to cut short that conversation, okay? All right, so here we go. The FOIA Advisory Committee recommends that the updated Office of Management and Budget fee guidance should provide clarity by clearly differentiating between two separate yet related issues, fee waivers and requester fee category status. Agencies need unambiguous, uniform guidelines on the criteria that must be met for each fee category. These guidelines should reflect the President's and Attorney General's guidance on FOIA and relevant case law, including embracing members of the media who publish primarily through electronic means. Do we have a motion that the FOIA Advisory Committee adopt recommendation 1?
I'd like to move an amendment to number 1. In view of things that have already been said, the sentence beginning "these guidelines should reflect," and my proposed amendment is "should reflect relevant case law and address members of the media, and specifically address members of the media who publish primarily through electronic means." So the point of the amendment is to delete the reference to the President and Attorney General's guidance and to replace the word "embracing."
I'm going to do a simple voice vote on this.
Can I make a friendly amendment to that? Sorry about this.
Okay.
I think we should incorporate the FOIA statute itself. I think you dropped out that piece of it, because it really should address both the statute itself as well as the relevant case law.
Should reflect the FOIA relevant case
Right.
law.
Correct.
Can I just say for the record, I mean, we need to handle one motion at a time, and it seems like.
They're creating.
This is Robert's rules allows for.
Yes, this is
Robert's.
It's confusing, but this is the way it works. So we have a vote, and Kate, you're capturing these for me? Okay, so
I
Kate.
accept it.
Wait, I just need to do a simple vote from the committee that this is going to be the new recommendation. The new motion on the floor is going to be to provide clarity by clearly differentiating between two separate yet related issues, fee waivers and requester fee category status. Agencies need unambiguous uniform guidelines on the criteria that must be met for each fee category. These guidelines should reflect the FOIA and relevant case law, including embracing members of the media who publish primarily through electronic means. Did I capture the changes? Okay, so I have that motion on the floor. We have the motion. We have a second.
Second.
Nate?
Second.
No?
Or I'll second.
You're going to second it? Okay. Now we're going to do a roll call on this one. I'm going to go to the phone, I believe. Dave Barr.
Aye.
Andrew Becker's not here. All right, Brent? Not here. Brenton, sorry. Yeah, I'm sorry. Aye. Thank you. Karen?
Aye.
Eric?
Eric did not call in.
Thank you. Larry?
Aye.
James? Jim? Thank you. Clay? Aye. Nate?
Aye, with concern. Aye.
Thank you, sir. Marty? Aye. Sean?
Aye.
Maggie?
Maggie had to leave.
All right.
It doesn't-
So Maggie had to leave early, and you guys might have saw the discussion. She was trying to determine whether or not she could give me her vote so I could vote in proxy. We're unsure about how that works, so we're going to table her vote. David?
Aye.
Melanie?
Aye.
Ramona's not here. Lee? Ann?
Aye.
Mark?
Aye.
Wonderful, and I'm an aye as well. Okay, thank you. We're going to go to recommendation 2. Oh, just for the record, that looks like that was a unanimous decision. Okay, so recommendation 2, the FOIA Advisory Committee recommends that the updated Office of Management and Budget fee guidance should provide agencies with additional guidance on what constitutes a representative of the news media that takes into account the changes in the journalism profession over the past 30 years due to technological advancements. These guidelines should be fair, balanced, and better enable agencies to make accurate fee category determinations. They should also clarify that fee categories are determined by the identity of the requester, not the particular request. Do we have a motion that the FOIA Advisory Committee adopt recommendation 2?
So moved. Second.
Okay. Dave?
Aye.
Brenton? Karen?
Aye.
Larry?
Aye.
Jim?
Aye.
Clay? Nate?
Aye.
Okay. Marty?
Aye.
Sean?
Aye.
Maggie? David?
Aye.
Melanie?
Aye.
Lee? Ann?
Aye.
Mark?
Aye.
I'm an aye as well. Okay. Recommendation 3. The FOIA Advisory Committee recommends that the updated Office of Management and Budget fee guidance should incorporate statutory changes to the FOIA relating to when FOIA fees can be charged. This includes 5 USC Section 5524A8, which states that certain fees cannot be charged when an agency fails to comply with any time limit if no unusual or exceptional circumstances apply to the request. Clarification is also needed as to which fees may be charged if the 20 working day statutory time limit is not met because unusual or exceptional circumstances exist. Do we have a motion that the FOIA Advisory Committee adopt recommendation 3?
So moved. Second.
Okay.
Can I have a clarification or if it's, sorry about this, it's just don't, if it's if it's a complex request, you actually get a longer period of time to process, or unusual circumstances, you get the 30 days versus the 20 days, and this only addresses the 20-day piece of it, not the 30-day piece of it. It sort of dawned on me as I was reading it again. And I don't know how to address that.
Well, this is Dave, and I don't know
Yeah.
if that's
The
automatic.
working limit, whatever, the appropriate working limit.
So I'll accept that amendment.
Oh, did we have somebody?
Charge, it would read, clarification is also needed as to which fees may be charged if the statutory time limit is not met.
Yeah, thank you.
Just one point of order on it. I mean, I don't read this, the first sentence is the main one, incorporate statutory changes.
Right.
The next sentence, this includes, but you guys didn't put the words, but is not limited to, but it implies not limited. So I mean, I don't care if we amend it or not, but I don't know if it's necessary, because it's not.
It says includes.
Yeah, it's not only isolated, it's not minimizing it or restricting it to this, it's just highlighting that one point.
Right, but I'm concerned that people would look at this and say, oh, they only care about ones where it's the simple request, a 20-day request versus a 30-day request. I'm just trying to bring more clarity to it, and I think it's not a major change, but it addresses potentially an issue.
Okay.
If the statutory time limit is not met.
Okay, so we have a motion, and we do have a second on that as well.
I have another motion for another amendment, if that, before we vote on that, or combine it with that one possibly. There is I don't know if it's typographical error, 552, it's section A4A. A4. I'm pretty sure it's A. So there's
you're
a
right.
paragraph, subparagraph, whatever we call it, is missing.
Okay, we caught that typo.
After 552 should be little a in parentheses, before the 4.
Good catch.
Thank you. Okay, so we have a motion, and we have a second on that. Okay. Dave?
Aye.
Andrew is still not here. Brenton? Karen? Larry?
Aye.
Jim?
Aye.
Clay? Nate?
Aye.
Okay. Marty? Sean?
Aye.
David?
Aye.
Melanie?
Aye.
Lee? Ann?
Aye.
Mark? Aye. Wonderful. And I'm an aye as well. Okay. Recommendation 4. The FOIA Advisory Committee recommends that the updated Office of Management and Budget fee guidance should provide guidance on fees associated with the reproduction costs, including providing electronic copies via email, CD, or DVD. The guidance should also clarify the costs that may be charged for reproducing documents that are transferred from classified to unclassified systems so that they may be released electronically. Do we have a motion that the FOIA Advisory Committee adopt recommendation 4?
So moved. Second.
I'm waiting. Okay, we're good? All right, Dave. On the phone, Dave?
Oh, yes, hi, sorry.
Okay, thank you. Brenton?
Aye.
Okay, Karen?
Aye.
Larry?
Aye.
Jim?
Aye.
Clay?
Aye.
Nate?
Aye.
Okay, Marty?
Aye.
Sean?
Aye.
David?
Aye.
Melanie?
Aye.
Lee?
Aye.
Ann?
Aye.
Mark?
Aye.
I'm an aye as well. Okay, recommendation 5. The FOIA Advisory Committee recommends that the updated Office of Management and Budget fee guidance should explain that agencies may use their administrative discretion rather than a formal fee waiver to decide not to charge FOIA fees when the interest of the United States government would be served. Do we have a motion that the FOIA Advisory Committee adopt recommendation 5?
So moved.
Second.
Okay. I'm going
I'd
to
like to make-
vote first.
Before we vote, can I suggest an amendment?
Yep.
Sorry about that. At the end of it, explain the agency may use administrative discretion rather than formal fee to decide not to charge FOIA fees when the interest of the United States government as defined by, or some type of parameters to where this can be, where the agency should codify this in their regulations or something. I'm just really concerned about having this open-ended. I mean, as Jim mentioned earlier, someone gets injured in the job, someone gets injured in war and you give the records. It's not a release through FOIA, it's released outside of FOIA. And I have no problem with that. OSHA did the same thing when I was at Labor. But I am concerned about having this open-ended, unbounded box without, if it was in regulations, as some organizations did, I'm fine with it, but there's some way to sort of balance it, so maybe
Hi,
recommend
this
the
is
agency.
Ann. I think this is a very valid point, and is there a way to amend it to say pursuant to guidelines that each agency shall develop, something along those lines?
Or some I could live with that, or even guidelines developed by OGIS or OIP, just something so I have something to hang my
I
hat.
take your point. I think it's a fair one. Obviously, the last thing we intended was to inject any unfairness in the system.
As an alternative to putting it on agencies to go through a process of adopting guidelines, would it be helpful to add at the end of what it currently says, when the interest of the United States government would be served and is clearly articulated?
This is Melanie. I think that part of the problem is the phrasing at the beginning where it's assuming the premise because it says explain that. So perhaps the way to capture sort of the consensus that we have, I think that we're sort of developing here is at the beginning could be something like consider whether and how, and if so, how agencies could use to have something like that.
This is Karen Finnegan-Myers. I was thinking we could say, provide guidance on how agencies,
Yeah.
OMB can provide guidance on
I
how
could do it
agencies.
as well.
Yeah, this is Dave, and I think since we're asking OMB to promulgate this guideline, we just put the onus on OMB rather than on the agencies and say, as interest would be served, as established by standards promulgated by OMB or something like that.
Yeah, that would work for me.
So the new motion would be provide guidance to agencies on how they may use their administrative discretion to decide not to charge FOIA fees when the interest of the United States government would be served. What's the next part?
And is clearly articulated.
This is Melanie, I do think we're going to have to say something like consider whether, because we do have a statutory standard. You know, there is a fee waiver standard in the statute, so I wouldn't want the archivist going to OMB as if we don't realize that there's what the statute says. So just having consider whether, and if so, how, or I just think we need.
Whether agencies may use their.
Yes.
This is Ann. To Melanie's point, I think it gets to a much more substantive issue, because I think it was the consensus, and subcommittee members, please correct me if I'm wrong, it was the consensus of the subcommittee after a fair amount of research that, in fact, the discretion exists. So if we're going to go, I mean, to me, that's a much more substantive change than what we have been talking about.
I agree with that. I think the subcommittee believes that agencies can and do, and 4 agencies' regulations say that they do. But again, let's work towards a consensus.
Yeah, I was going to say, well, so now let's think of a way to say it so that we'll all feel comfortable, because we really are just talking about a couple words. So I feel like we're so close on that. How about address the use of administrative discretion?
Or develop guidance on the use of administrative.
that?
Yeah, that's back to where you said originally.
Right.
Provide guidance too. And, you know, I feel like provide guidance, at least as the motion maker, it reflects the purpose of the document well here. I mean, everything else almost is about
saying,
providing guidance and providing clarity. Right
so
now
could you read it again, what it would say?
So right now, my motion is to provide guidance to agencies, I'm sorry, I'm reading from yours and mine.
What I'm suggesting is we've already got guidance up in the introductory sentence. So OMB fee guidance should address how agencies may use their administrative discretion.
Got it.
I'm trying to think how agencies could you say it one more time? I'm sorry.
All right. With the introductory sentence at the
Right.
top, the FOIA Advisory Committee recommends that the updated OMB fee guidance should, number 5, address how agencies may use their administrative discretion rather than a formal fee waiver to decide not to charge FOIA fees when the interest of the U.S. government would be served and is clearly articulated.
I'll accept that in the interest of time. Is that good with the subcommittee?
I'll second that.
Okay, so we have a motion and a second.
Dave says aye.
Thank you. Brenton? Aye. Karen?
Aye. Larry.
Eric, you're right, he's not here, Larry. Okay. Jim?
Aye.
Clay? Aye. Nate?
Aye.
Marty?
Aye.
Sean?
Aye.
He's gone. David?
Aye.
Melanie?
Yeah, aye.
Okay. Lee? Ann?
Aye.
Mark? Okay. I'm an aye as well. Okay, recommendation 6. The FOIA Advisory Committee recommends that the updated Office of Management and Budget fee guidance should recognize that FOIA fees cover a very small percentage of FOIA costs. In fiscal year 2014, agencies processed 647,142 FOIA requests at a cost of $462 million and recouped just $4.2 million from FOIA fees, less than 1% of the reported cost. Moreover, these fees are paid to the general fund of the Treasury, not to the agency's FOIA offices. The current OMB guidelines appear to be missing a word in Section 8, which adds ambiguity to this expectation. So do we have a motion that the FOIA Advisory Committee adopt recommendation 6? So moved. We have a second?
Second.
Okay. Dave?
Dave says aye.
Okay. Brenton? Aye. Okay. Karen?
Aye.
Larry?
Aye.
Jim?
Aye.
Clay? Aye. Nate?
Aye.
Okay. Marty?
Aye.
Sean?
Aye.
Okay. David?
Aye.
Melanie?
Aye.
Lee?
Aye.
Okay. Ann?
Aye.
Mark?
Aye.
Okay. I'm an aye as well. All right, so now we've gone through all the hard work. Now I'd like to vote on the main recommendation that the committee considered back in January. As a committee, we unanimously agreed to recommend that the archivist ask OMB to revise its 1987 guidance. In light of the motions that we approved today on the 6 sub-recommendations, do we have a motion that the FOIA Advisory Committee recommend that the archivist ask OMB to revise its 1987 guidance to include the 6 sub-recommendations? Okay, we'll just do, I think a voice vote will be okay here. Okay, all in favor? Aye.
Aye.
All opposed? Abstain? Wonderful. Awesome. All right. So it appears that the number of votes is higher, it passes. We're now going to finalize the memorandum and submit it to the Archivist of the United States. I'll invite the committee members in attendance to approach the table over here, and I will then ask the members calling into the committee whether I may sign the memo on their behalf. All right. Yes.
So have we,
Yes.
by what we've just
Dave Bauer
done,
Yes.
says you may, yes.
Ann Weissman says you may sign.
Thank you. Well, I'm sorry, Ann, what?
You may sign on my behalf.
Thank you.
Thank
have
you.
we, by virtue of what we've just done, amended page 10?
Yes. Of the final report?
Yes.
I'm not sure that we amended it because what was included in the report was an actual copy of what was submitted by the subcommittee. So
Is there any reason why we can't amend it?
Yeah, I'm not gonna reopen that report up because it's,
Well, there's no issue, because we've changed the recommendation.
right, but I don't have the resources of my staff to go back and start playing with the report. That everything up until that point was reported on as being past tense because it was submitted by the subcommittee to the committee. It was incorporated, and then everything from this meeting was presented as present tense. So we would then have to go back and say, okay, now we had the committee and open up the report.
Can you add a footnote somewhere that says this was subsequently amended?
When we blog about, I mean, this is gonna go live after this meeting, once we report it to the archivist, because that's also part of the problem. I'm handing the report to the archivist, a signed copy of our report. It will go live on the website, and we will be able to address, I mean, we're gonna be blogging about this. We have the actual pen and ink changes to the memo with your signatures on it, which will also go up as well. So all of the changes and whatever transpired, including the minutes from this meeting, will go up on the website and capture what transpired during this meeting.
Could we have this, Melanie, could we just do an addendum that
We-
goes, addendum to the report that could be posted along with the minutes? And
Right.
That way you don't have to change anything you have now, but it would officially be
Well,
something that gets attached.
the only
Does that
issue,
work?
and I think you actually brought it up, and you made a really good point, which we incorporated into the report, is that this was the work of the subcommittee
Subcommittees.
at the time that they submitted
Yeah.
it to the full committee. And that's how we treated each
Section.
report, with each section in the report. And I think that it makes sense, for consistency's sake, that we continue along those
Yeah.
lines.
Okay,
It's a
no, that's
record.
right.
Yeah, it's a record.
It's a record.
Right.
There we go.
James, I have to leave, so you have my approval to sign on my behalf?
Thank you very much.
Thank you.
I really appreciate your attendance today.
Yeah, I think as long as this final version is posted on the website, and this is what was approved by the committee, I think you're probably fine. But-
Okay, so we are a little bit behind, so we're gonna kind of move these things along. Let me see where I'm at. All right, so I'm gonna call you up real quickly. Actually, why don't we just start on this side of the room? And I have the memo. If you will sign your name, approve and date. Okay, so we're gonna have each committee member come up. We'll just start on this side. If you'll sign the memo. We have made the pen and ink changes, which will be reflected. when we submit it to the archivist. And while they're doing that, I'm going to begin introducing the archivist, and he has a few prepared remarks as well. So as we alluded to earlier this morning, the Archivist of the United States, David Ferrero, has recognized and reaffirmed the importance of this committee and its efforts by working to renew the committee's charter until 2018. As a champion of open government, the archivist values the importance of a committee that brings together government and non-government FOIA experts to make recommendations to improve FOIA throughout the executive branch. He joins us today to observe and offer his thoughts on open government and this committee's efforts to accept the committee's recommendation and offer his thanks to the committee members who are completing their 2-year terms. After the archivist's remarks, we will present him with the committee's recommendation. He, in turn, will present the committee members who have served 2-year terms with a letter of appreciation before turning the floor back over to me for closing comments. Ladies and gentlemen, the 10th Archivist of the United States, David S. Ferrero.
So just a quick observation. Those folks up on the hill don't hold a candle to what you just did. It's my privilege to take this time to thank each of you for your service to the FOIA Advisory Committee and your respective subcommittees. As you are aware, the committee was established as one of our commitments in the U.S. Open Government National Action Plan. Specifically, that commission called for the creation of a formal FOIA Advisory Committee comprised of government and non-governmental members of the FOIA community to foster dialogue between the administration and the requester community, solicit public comments, and develop consensus recommendations for improving FOIA administration and proactive disclosure. And we just saw a wonderful demonstration of consensus carried out right here in this room. Since you first met in June 2014, the Fees, Oversight, and Accountability and Proactive Disclosures subcommittees have considered some of the most pressing issues facing the Freedom of Information Act. This work has been challenging, but I applaud your commitment to soliciting and receiving input from FOIA requesters and agencies as you examine these issues. This process reflects the Open Government Partnership's vision of genuine dialogue and collaboration between governments and civil society to improve the quality of governance. Your work and recommendations to improve the FOIA process also serve the National Archives' mission to make access happen. While your terms as members of this committee end today, I know that you will join me and the rest of the FOIA community in watching the continuing work of this committee with interest. I expect to renew the committee's charter as part of our National Archives' ongoing commitment to open government. As we think about other commitments that the National Archives can include in the next Open Government National Action Plan to make government more open, transparent, and participatory, I encourage you all to share your ideas and feedback with us. At this time, I'd like to present each of you with a letter expressing my appreciation and that of the National Archives and Records Administration.
So I'm supposed to start reading now, correct?
First, we have to do some of this stuff.
Okay.
So this is also a photo op from when you get the letter.
So, yeah, I got it.
I know. I knew nothing about whiskey. Larry Gottesman. Jim Hogan. Jim's a hard worker.
Oh, another one.
Nate Jones. Clay Johnson. Marty Michalowski. Melanie Priste. Lee White. Mark Zaid. And we have former committee member Ginger McCall joining us. Some of you gentlemen on the committee still have more work to do, but if you would like your picture taken with the archivist, David Pritzker. Sean Moulton. Brent Evan. Well, they didn't start at the same time that you guys did. So like Brent started in like November, October 2014.
Here is the signed actual report. You will get a copy. All right, so we have gone long. So before adjourning the meeting, I just want to take a moment to say thank you to all of the committee members, present and past. I'm very proud of the work this committee has been able to accomplish over the last 2 years, and I hope that you are also proud of your accomplishments to improving the FOIA process. In addition to working together to develop and deliver a strong consensus recommendation to the archivist on how to improve the FOIA process, the subcommittee's work over the last 2 years has greatly improved our understanding of some of the biggest issues in the administration of FOIA. And so as you reflect on your work, remember that the final report of this committee's work is not an end product. It is simply a starting point for the committee's 2016-2018 term. As you know, we began this committee to meet a commitment in the administration's second Open Government National Action Plan, and I believe this committee's accomplishments are proof of the benefits of an open and participatory and collaborative government. I invite everyone to visit our website at ojis.archives.gov and also follow us on social media for more information about our activities and how you can participate. We will keep you posted as to when the committee will hold its first meeting of the 2016-2018 term. I look forward to seeing you then. Before exiting this room, please note that all of you must undergo the National Archives exit screening procedures to leave this building. So for security purposes, security staff will inspect your bags. Thank you guys. I really appreciate it. Stand adjourned.